Number 32 on the calendar, People v. Roy Gray. Rebuttal time, counsel.
Your Honor, I'd like 3 minutes for rebuttal.
You have 3 minutes.
Thank you. Sarah Gerwich, Office of the Appellate Defender for Roy Gray. Your Honors, by failing to move to reopen the suppression hearing, what defense counsel did here was he just forfeited the possibility of a dismissal with no benefit to his client. Now, I know that my adversary has argued in various forms that there was some strategy here, but that just doesn't make sense.
Was that true that there was a risk that that actual second verbal substantive statements that were damaging would have gotten in? There's no risk that that might be the outcome?
That was certainly a possibility, but it wouldn't have harmed Mr. Gray. Let's look at the two different...
Doesn't the whole strategy depend on his argument that I've got that one statement up front that he really just did this to protect his brother?
Well, Your Honor, that assuming that they had lost and the written statement is in the case, defense counsel's strategy with the written statement in the case is he's going to use the initial statement, the kind of ambiguous statement, I'm going to take the heat for my brother. And then he takes the heat for his brother and makes a false admission. If he makes a false admission, orally and then written, still false. It's orally written in video, still false. That same argument is available.
What are the contents of that second oral statement?
The second oral statement is a confession. It's the same as the written statement.
Nothing additional. Nothing more.
Actually, the oral statement is just a little bit shorter, but it's an admission, and it's consistently referred to, the written statement, as reducing the oral confession to a writing. So it's the same statement.
Counsel,
yes,
I'm
sure.
sorry. I want you to finish your answer to Judge Rivera's question.
Right. So, I mean, there's no greater harm. This strategy could have been the same, but what really would have benefited Mr. Gray is if the statement was not, the written statement, the admission was not in the case, and there was a substantial argument in favor of that. Yes, Your Honor.
No, I was just thinking through what you said about there being no risk to having the additional oral statement come in because the strategy would be the same with the oral statement and the written statement. So that sort of suggested to me that even there was a strategy, there was no reason to reopen the suppression hearing because the strategy would be the same.
Well, no, the reason, Your Honor, was because there was a very strong argument in favor of no attenuation. And if they had won at the suppression hearing, as they initially did, and then it was reversed.
Well, what if the detective testified, maybe there, I'm not sure why the Supreme Court or the trial court thought that the oral Miranda warnings were incomplete, but what if the detective had gotten on the stand and from memory just stated each Miranda warning and they all matched up to the Miranda warnings that would have been considered complete? Then the whole original statement would have come in, right?
Yes, but, Your Honor, again, Mr. Gray wouldn't have been in a worse situation. That, of course, was a possibility that if defense counsel had done what he was supposed to do and what the CPL directs, that if something new comes out, you make a motion to reopen the suppression hearing, you go back to the suppression court. If he had done that, and it turns out that Judge Marvin, the hearing judge, had said, there's actually no Miranda violation here, and therefore the oral admission and the written admission, they're both in the case. Mr. Gray's not in a worse case.
Does defense counsel's considered strategy trump that?
Defense counsel's reasonable strategy is what this Court needs to look at. It's the standard of this Court and the Federal courts is not, did defense counsel have a reason? It's, was there a reasonable strategy? This was not a reasonable strategy.
Wasn't there a DNA strategy here? Or maybe I'm misunderstanding. So the allegation is of of failing to meet the standard is when this comes out during trial, he doesn't move to reopen the hearing, right? That's the allegation. At that point, he knows they have this hat with DNA in it, right?
Correct.
So I understood the strategy to be, I want the statement because at least it explains away my DNA being found in the apartment, but it gets me off a first-degree murder charge, which is a life sentence, which
Your
is, in
Honor,
fact, what happened, right?
Yes, he was acquitted of the first degree, but I don't think that that is what defense counsel said his strategy was.
But it doesn't matter, right, what he says his strategy is. You just told the court, didn't you, that is there a reasonable strategy?
Right, and that wouldn't be a reasonable strategy, that the additional DNA evidence that comes out, that it's conceded by the government that the DNA evidence is not enough to convict Mr. Gray, that this case turns on the statement, that it's conceded at page 63, footnote 19 of my adversary's brief, that without the statement, this case is legally insufficient. So here, to pursue a strategy to deal with weak evidence, which there's no suggestion that's what happened here, where the other alternative is that the evidence in the case, the admission, it could have been out of the case, and then there is no dispute that without the statement in the case would have had to have been dismissed.
What about the appellate division's statement, which sounds to me like they're saying that you would have lost anyway on the suppression? Does that make a difference here?
Well, the problem is the appellate division used the wrong standard, and I know the court
Well,
is...
they may have, but it can also be interpreted as saying this would not have been suppressed.
Well,
Not just that it's a high burden, but that in no way could the burden have been met.
Your Honor, I think there are two answers to that. One is the court looked to whether it would have been a winning argument and found that it would not have been a winning argument. Now, winning argument is not the proper standard when it's the failure to do something. It's the Claremont standard. Was there a substantial argument, and if you were successful with suppression, would the suppression result in a significant change in the outcome? Here, that standard is met. So to say, well, they made this decision using the wrong standard is something this court should defer to. But also, what did they look at? They looked at this small amount of evidence that came out at the trial when what we needed was to go back to the suppression court. I mean, this is a situation where we have one account that comes out in the suppression hearing.
So you're saying if they had the suppression hearing, there would have been, similar to the last case we heard, there would have been possibly more evidence that would have come out, and we don't know what the outcome would have been.
Yes, but also, Your Honor, the appellate division was wrong on attenuation, not just the standard, but also wrong on attenuation. Under this court's attenuation law, looking at the Pullman factors, that to say that this was not a strong case for no attenuation, it was just wrong on the law. I mean, we have the initial statement, the non-inculpatory statement, and then we have the admission, which defense counsel argued was false, that is taken by the same personnel, the same detective, so one of the Pullman factors, in exactly the same location, without any significant time break. So to say, oh, this is a clear loser.
So are you talking about the statement made after the New York form was faxed, or another statement before that?
I'm saying that the appellate division's determination that the written confession was attenuated from the Miranda violation.
The one that was done 45 minutes after the oral statement?
After
After the Miranda ones.
there are two oral statements.
Okay.
So there was the first oral statement at 7 o'clock, which is not a confession. Then there's the extended questioning, which the suppression court did not know about, the appellate division didn't know about in the first decision. So it's about an hour, 10 minutes later. So from the Miranda violation to the the written statement that the appellate division found attenuated, it's more than 2 hours. So there's just...
Well, to narrow this down, doesn't your argument, you could state it better than I do, but doesn't your argument come down to the fact that in the second appellate division decision, the one that dealt with the consolidated trial decision and I think the 440, don't they say at that point that even if we accept that he had a stronger argument to win his suppression motion, but he didn't have a winning argument to win his suppression motion because during that hour and 10 minutes there was no attenuation, he was in fact questioned during that whole period. If that's the case, then they have the wrong standard. It's not, you don't have to show a winning motion. You've got to show a close question, a substantial question,
a substantial question.
That's your whole. That's the argument.
Yes,
that's what it boils down.
It's the wrong standard, and so we can't defer to the appellate division's decision based on the wrong standard. So, I mean, if there's any place for the winning standard, it's certainly not in a case like this where there needed to be some additional fact-finding, where the suppression hearing needed to be reopened. I mean, it's a real, we have a very problematic record here, and we don't really know why we have this record. We have one thing that the detective is saying in the suppression hearing. Turns out it's not accurate. We have the government presenting in its brief, the first brief to the appellate division, a timeline that turns out to be totally inaccurate. So in terms of what defense counsel should have done, I mean, it couldn't be clearer under the CPL. He should have moved to reopen. If he had moved to reopen and the court had again found no attenuation, the statement would have been out of the case and the case would have been dismissed. That was something that simply could not be forfeited in favor of a reason that was not a reasonable strategy. There was no benefit to Mr. Gray. So this court either can look at the record and say, based under our Paulman analysis, there was no attenuation, the case should be dismissed, or could send it back to the suppression court for the reopened suppression hearing. Thank you, Your Honors.
Thank you.
Counsel, is that true? There's no prima facie case without the statement?
Well, the statement certainly weakens the case substantially, but we weren't actually asked to what happened was when we first came up with our People's Appeal, we didn't have the DNA on the hat. So we're kind of looking at it in hindsight and saying, well, how much does the DNA on the hat matter? And, you know, it's difficult to say. Certainly the statement is substantial. We're not going to deny that.
If it was necessary for the people's case, what could the possible strategy be for not opening the suppression hearing?
Yes. Well, I need to take issue with something counsel said a minute ago. You see, here's the thing. The written statement was written by the detective, Detective DePaulis, and then just signed by the defendant. So it's very different than the oral statements, unlike what counsel was arguing a moment ago. So if you had the oral statements coming in where he's voluntarily spewing this stuff.
Is that the difference, or are there substantive content difference?
Well, I mean, it's similar. Here's the thing. It was if you go to the strategy, because again, we're under the very narrow framework of an ineffective assistance window here, and even narrower because we're talking about one error, so a very, very high threshold here. But if you look at the strategy, the attorney is saying, I'm bringing out the statement that I'm taking the weight from my brother. Then I'm going right to the written statement, which was written by the detective. Therefore, I can make the argument to the jury here that the written statement is a distortion, number one, and in any event, he's taking the weight for his brother. It becomes much more difficult to do that when you have a series of oral statements that are basically reciting what the written statement said before Detective DePaulis even put his pen to paper.
They never made the argument that it was a distortion. That the argument all the time was that it was it followed from his. It was a false confession following from the initial oral statement that this is what he was going to do. He was going to defend he was going to take it for his brother.
I'm sorry.
I don't understand really how that argument is weakened if the oral statement comes first and the written statement is whoever wrote it is essentially incorporating what the second oral statement was. I just don't
Well,
see that.
Mr. Bruno did make the argument in summation at several moments. In fact, he also cross-examined Detective DePaulis extensively on why did you take the written statement, and he attacked it viciously, well, not viciously, but he zealously attacked Detective DePaulis on, at one point he couldn't remember why he was the one who wrote the written statement, and then he came in and later testified that he could remember why. So he used this in summation to say, Detective DePaulis here, he's writing this statement, he's trying to tie up, in fact, he uses these words in his summation.
I thought that's what the lawyer said in his affidavit, that he attacked the methodology, and he said
He also
the
said
written
in his-
statement was an opportunity to embellish these facts.
Correct. He also argued this in summation. He said,
Yes,
he
but
sees...
the point is that that's after the statement's not suppressed. He's then going to make the best argument he possibly can based on what's in front of the jury. But how can that possibly be better
Yeah,
than
because-
having all the statements thrown out?
Because here's the thing. Well, that's true if all the statements would have been thrown out. But number one, they wouldn't have been thrown out. The appellate division decisions...
That's the issue. We don't know whether they would have been thrown out.
Well, I understand Your Honor's point. But the first thing is, if he had reopened the suppression hearing, it is very possible that Detective DePaulis would have come in, and this was, incidentally, this lawyer, we tried to move early on to get the suppression hearing reopened in order to clarify those early oral Miranda statements. But Mr. Bruno, at that time, wisely said, no, we're going to fight you on reopening this hearing. And so we actually wanted to get more in. It may have clarified this whole thing and we wouldn't be here. But be that as it may, the fact is then to ask him to later on come and say, yes, I want to reopen this hearing right now and possibly get an hour and 10 minutes worth of what he's saying in the written statement to come in orally. See, now he can't argue. He said on summation, Detective DePaulis is trying to tie up the loose ends here. That's why he's writing the statement. That's why it's a distortion.
Her point is if he had lost the suppression, he's in the same place. Why is he not in the exact same place?
Because then if he loses the suppression hearing, it's very possible that all of the oral statements come in, and now he has this enormous weight. He can't argue that maybe the hat was worn by someone else because maybe he wasn't even there, and maybe
I
Detective...
mean, that second oral statement is the one that gets in. That,
Right,
in
really-
addition to.
Really what happened here is when you had at the suppression hearing, it wasn't clear, when the taking the weight and when it goes into the questioning. But what is clear is there were some sort of oral Miranda warnings at the beginning, at the very beginning before everything, which takes this well out of the purview of Siebert and all these other cases. But, I mean, here's the other point that I want to get to Judge Stein's question. Not only would it have not made sense, because now the weight of his confession becomes so much graver and so much greater with all these statements, and you can't argue that DePaulis is distorting things because, distorting things just on the written because he has all this oral stuff. But he also wouldn't, there's no really clear-cut dispositive issue here because there's no clear-cut issue that it would have been successful to begin with. And the appellate division relied on the same factors in its second decision, most of which it continued to rely on those same factors that it found in the first decision, that there were numerous warnings of this defendant. One oral Miranda warning, which we don't know the stakes of at the moment, but then a North Carolina Miranda warning, then a 45-minute break, which is a substantial break. Not only that, but professed willingness by this defendant. Counsel brought up the Paulman case. In the Paulman case, it makes clear that a professed willingness is something that should be taken into consideration to whether or not this defendant is returned to the status of voluntariness, even if there is an issue. Further, this defendant had over 10 years, 8 arrests, or I might be getting that backwards, 8 arrests over 10 years, one or the other, but he had an extensive criminal history, which alone also brings him back to the status of somebody that's voluntarily giving a statement. So this is not one of these issues where it's a question first or we're trying to get him around Miranda. Could it have honestly been fleshed out a little bit more? Perhaps. But I wanted to address Judge Fahey's point from the last case, which is which standard do we apply. I would argue that the standard that we apply depends on the ineffective assistance claim. So if it's a single claim of error, that's the rarest kind of ineffective claim, and that for that, McGee is instructive, where it's clear, it's dispositive, there can be no strategic impetus behind it. those are those kinds of cases. That's the kind of case that we have here. For other types of cases where there's a litany of errors, then yes, then I would argue that, sure, Claremont should be the standard, because in those types of cases where there are a litany of errors, then maybe a substantial arguments type standard makes sense, because the prejudice is greater.
Exactly. When we talk about clear and dispositive, we talk about things like statute of limitations.
Correct.
Things like that. How can you compare this with a statute of limitations argument, which is absolutely no question, it doesn't even go to the jury?
I don't know how I could say it better. A statute of limitations defense, that's a dead bang winner.
That's right.
Versus this particular case, where if you move to reopen the suppression hearing, as any good defense attorney knows, and this was a very, very well-experienced defense attorney, you could be opening a Pandora's box. When I have a defense here, and it's viable, and it could persuade a jury, and in fact it did persuade a jury to acquit on the top count, why am I going to risk reopening that Pandora's box if it could come back and bite me and make it even harder for me to assert any defense for this defendant whatsoever? And more to the point, you know, as far as
Sorry, Counsel, before you move on, are you saying that there was no possibility that any of the statements could be suppressed if the suppression hearing was reopened?
Well, the point is that if Detective Paulus came in and said, yes, my initial Miranda warnings were as follows, 1, 2, 3, 4, 5, whatever, and they correlate exactly with the New York State standard, then there's no basis to suppress any of these statements, anything he said. And that's the real risk.
If that were not the case, and all the statements, there was no, or the court found there was no attenuation between the second oral statement and the written statement, do all the statements go out?
I'm sorry, if there was no attenuation between the second and the, I'm sorry, could you repeat the question one more time?
There were two oral statements, correct?
Correct, yes.
And the issue here is whether there was any attenuation between, I guess, the second oral statement and...
Well, more the second oral statement and the written
statement.
And the written statement.
So do they all, if there is no attenuation, do all the statements go out?
I suppose that's possible if there's no attenuation, but you know, under all the different factors, most of which the appellate division continued to rely on in finding that this statement was still good under Miranda, I mean, the likelihood of success here is not small. And furthermore, the court showed no inclination necessarily one way or the other to reopen the suppression hearing. So we don't even know even if the motion had been made, whether that would have been successful and they would have reopened the suppression hearing. I just want to touch briefly, the appellate division standard here did not apply the quote-unquote winning standard, as my colleague suggests. They were very specific in saying reasonable probability. When they talked about winning, that was clearly dicta to show that under any standard, this wasn't going to win. That was not we're applying a brand-new standard that's never been done in this State before. Furthermore, the quote-unquote, the dicta of whether or not it's successful or winning, that dicta has been used before by this Court in Turner. So that's nothing new, and that doesn't implicate a new standard. They were very clear that they were using a reasonable probability standard.
Did Turner involve a suppression motion?
Well, Your Honor, in this particular, did Turner involve a suppression motion?
Well, I guess what I'm asking is, have we ever used that standard in a case involving a suppression issue?
I don't know the answer to that question. I honestly don't know the answer. But, I mean, again, we're in the narrow framework of an ineffective assistance claim. So it's not just
I'm talking about an ineffective assistance.
Ineffective assistance for a suppression.
For suppression.
Right. But I would even go further and say this is an ineffective assistance claim on a suppression motion where they're claiming one error, and only one error, and that being the suppression issue here. Furthermore, as far as the fact that the appellate division did, in fact, rule as it did the second time around, once more, in terms of the framework of an ineffective assistance claim, this shows that it was reasonable for Mr. Bruno to come to the decision he did. In other words, although new facts came out, and I wouldn't even call them new facts, they were clarifications because it was said at the suppression hearing, it was understood sort of that there was an oral statement. It just wasn't, the timing was a little bit murky. But when things were extrapolated at the trial at that time, a lot of the primary facts didn't change. And in fact, Mr. Bruno states, as far as strategy goes, he even states, and this is on the supplemental appendix, page 425, because at no prior occasion, including the hearing, is the verbal conversation fleshed out. The detective could sit there today, theoretically, for 2 hours, saying that Mr. Gray confessed to every unsolved murder in the world. Not that I'm saying he would. This was the fear, and it's right there in the record, that he was worried about what could come out at the suppression hearing. And once again, I understand Your Honor's reluctance because, hey, isn't the written statement as good as the oral statements in this case? But in this case, it really isn't as good because Detective DePaulis wrote it. Detective DePaulis' testimony at trial was a little bit all over the place as to why he wrote that statement. So therefore, defense counsel reasonably could have used that statement and did use that statement in summation to say, hey, wait a second, this can't be relied on. Much more difficult if there are oral statements. Unless Your Honors have any further questions as far as the second point in my opponent's brief, we will rest on our brief. Thank you.
Thank you, sir.
Your Honors, in response to your question, Judge Stein, this Court has never used the Turner-Keshner standard in a case involving suppression hearing. It's only been applied in cases where there was a pure legal issue. And analytically, that makes sense. If there's a pure legal issue and all we're missing is what an attorney would have argued, a reviewing court can figure that out. But where it's suppression or some other issue where there needs to be fact-finding, then the Turner-Keshner standard could not and has never been applied by this Court. It's the Claremont standard that should be applied. Also, just in response to the notion that the appellate division did not use the winning standard, it did use the winning standard. First, it said a substantial reason, and then it defined it as winning. Might be better in terms of attenuation, but not winning. So that's clear.
Counsel, what about the idea that if you reopen the suppression hearing, you reopen it for all purposes?
And yes, that it would reopen it for all purposes. It could result in a finding that there was no Miranda violation. Does not put Mr. Gray in a worse position.
Well, I don't know about that. In fact, didn't his lawyers say, well, you put these detectives back on, they're just going to lie and make it worse?
Right, and so
they were pretty cynical about the people's case, and it doesn't bother me. I mean, if he says, I don't want these guys back on the stand.
And couldn't the oral statement have come in?
But Your Honors, what's the worst case scenario? So let's say defense counsel's fear was right, that they go back in front of the hearing court and they clean up the Miranda record. The court says no Miranda violation, and so we're back in the same place.
They're not. You have an oral statement that now comes into trial.
Right, and so remembering that the theory is defense counsel is going to, once there's an admission, I mean, it's not so much a question of whether it's oral, written, what the format is. There's a confession. Defense counsel is going to say, first he said, I'm going to take the heat for my brother, falsely. And then he took the heat falsely for his brother. So once there's that strategy, once it doesn't matter.
You say that. It would bother me. I'm not sure I'd want to have more stuff laid on my client, you know, when they testified than what I've got now.
But
What about the argument about the methodology, though?
I think it would be the same thing, that if the
How is that?
If the detective
You want to say it's one thing, right? It's one thing if my client had actually said it, but here the cop wrote it, or the investigator wrote it, and in fact was able to embellish the facts or change the facts, and that shows that this is not really a voluntary statement by my client.
Right. So we're saying if the detective was either making an error or maybe his credibility is at issue.
That's an error, right?
If either of those things, you can say that about the oral statement. The oral statement comes in, you need the detective is the messenger there as well. You can make the same argument.
But if they've made they get more, I think as Judge Garcia was pointing out, if they're getting in more information about the warning, doesn't that put the client or the defendant in a worse position?
Your Honor,
Make that argument that the attorney wants to make, potentially a very powerful argument, less credible to the jury.
It does not. And what would have been an extraordinary benefit to Mr. Gray is the statement not being in the case. And there was a strong argument in favor of no attenuation. I'd just like to briefly address the DNA.
Well, how wrong does the lawyer have to be about that particular strategy call?
There has to be a substantial argument. It's the Claremont standard. Here there was certainly a substantial argument. The fact that we can also...
No, I'm not asking about the argument.
Oh, I'm sorry.
I'm asking about that risk.
Oh, how...
Where do we draw the line about the risk?
It has to be
a
reasonable.
lawyer could say there is a really, might say that I got a really powerful argument, but the risk, even if it's 1%, is just too much for me to pursue.
Just to have a reasonable strategy. I mean, let's look at a hypothetical. Let's say that at the end of the prosecution's case that the defense lawyer has a strong argument that the evidence is legally insufficient and says, you know what, I'm not going to make that argument. What I'm going to do is I'm going to wait and I'm going to put on my alibi witness. That's a better way to go. I feel better about that. Well, that wouldn't be reasonable, because if you have a strong argument in favor of dismissal, you make that argument. That is effective assistance of counsel.
Nothing bad is coming out of the first argument you're going to make. What bad thing can possibly happen to move to dismiss? You still get to put your alibi witness on later, even if you lose.
And, Your Honor, I think this is analytically the same. I think that this is not a real risk, that there's any harm.
That's what you think, though, now. But the defense lawyer didn't think at the time.
There's nothing to suggest that he gave a consideration to reopening.
So you're saying there's no reasonable attorney at that point could have said the risk outweighs the potential benefit?
Correct, Your Honor. And just very briefly on the DNA, that the prosecution has conceded the DNA was not enough in this case. It's very weak DNA evidence, just keeping in mind that initially there was no DNA profile at all that could be generated. Then years later, a different method is used, and it's found that my client, according to the new profile, is one of a number of contributors. It's a very chaotic scene. And, you know, we don't know how the hat got there. I mean, this is
Okay,
not
counsel, thank you very much.
Thank you, Your Honors.